Welcome everyone, my name is Rilus. In today's video, I'll be talking about two of my favorite topics. We're going to be talking about real estate and probate. So I have a checklist for you. So if you look in the description, there's a download where you can download this checklist. I get lots of calls, lots of messages from people wanting to know if I have a few minutes, if I can talk to them about the deal they're working on. So go through this checklist. This is going to help you if you're in that situation. Oops. Here we go. And then if you've gone through this checklist and you can tell me these details about the property, I'm more likely to help you. I practice law in Arizona and California. If you're in any markets, this is the information that the attorney is going to want to see. So this is going to help you understand what's going on, to know how to analyze this. And then when you go to get an attorney involved, they're going to like you if you have this information for them. All right, so we're trying to figure out who are the persons or company that have or can obtain the authority to sign a contract. All right, there may be a great deal to buy a property, but you want to make sure that someone has the authority to sign your contract. That's the starting point for everything that I do. So who has the authority to sign your contract? Step one, who are you talking with? If the person that you're talking with is also the person on title, then there you go, you're done. So step one is the name of the person you're talking to. Maybe it's Susie Smith that you're talking to. Now, if the property is titled differently, then it's a different story. So if the title, if it's proper, so I want to know exactly how it's titled. Pull the deed and see exactly what it says. If it says John Doe and Jane Doe, I want to know that. I want to know exactly what it says. Or does it say John and Jane Doe, husband and wife? Does it say John and Jane Doe with rights of survivorship? These are some of the choices and some of the magic words, but we want to know exactly what the title says. And then we want to know, all right, so in my world, if you're getting me involved, a probate attorney, someone's probably dead on title. So if it's John Doe and Jane Doe, does their share pass to the other owners? So if so, the remaining owner can sign your contract. So I did another video about rights of survivorship and tenants in common, so you can go back and look into that. If the title does not specifically say rights of survivorship or husband and wife, then it's presumed that it's tenants in common. So if it's tenants in common and Jane Doe has passed away, then what we need to do next is see what controls their estate. So an estate refers to everything that a person owns, whether alive or dead. So in this case, we're talking about the estate usually means someone's passed away. So if the name of a deceased person is on title, we see what controls their estate. If they have a last will and testament, that's a document that controls their estate. So that's going to name the personal representative, which is the person that can sign a contract. So that's what you're looking for. So if that's the case, you found a will and a personal representative, then there you go. Now, if there's no last will and testament, then what do? So what you need to do is you need to determine the family members. So see if they're married, if they had kids. And then if they have kids, you also need to know if the kids are common to the relationship, or were they from a prior relationship? And then you're going to look up the laws of intestate succession in that state. Intestate succession, that means who gets it if there is no will. And that's also going to determine who has the priority to serve as a personal representative. Now, if there's 5 kids, all 5 of those kids are going to have the equal priority to serve as a personal representative. That's right, all 5 of them. So they're all going to have to do something, or at least agree to name one person. Now the next step I like to go through is to see if a probate is actually required. So the first part is who's going to sign the contract, and then the next part is how do we get them the authority. So after we figured out who can have the authority or who does have the authority, we want to see if there's an alternative available to probate. So we look at the tax assessed value to determine this. And I'm going off of Arizona law on this, but most states have some sort of probate substitute. So to figure it out, start with what's the tax assessed value of the property. If that's $150,000, then the next step is see if there's any debt on the property. Is there a mortgage? Is there any other secured debt on the property? And you do get to subtract this from the value, from the assessed value. So if there's a mortgage of $75,000, then the net value is $75,000. Then the next thing you need to know is when did the person pass away? If they passed away yesterday, this affidavit and substitute's not going to be available yet. In Arizona, the rule is you have to wait 6 months after the date of death, and if it's less than $100,000. And another important requirement is there's no other assets in the estate. So even if the house is less than $100,000, if there's also bank accounts that need to be collected and other assets in the estate, which requires a probate, then this affidavit's not available. If you have to open a probate for one thing, then you need to collect everything through that probate. So that's it. So let's go through them again real quick. So big picture, who's going to sign your contract? If the person you're talking to is not the one on title, then you'll figure out what's going on. If someone is deceased on title, who has authority for their estate? So if there's a will, that's going to tell who has the authority for the estate. If there's no will, then you figure out what family members have the right to serve as a personal representative. Once you figure that out, who's in charge, then you need to figure out if a probate is necessary. This is something that an attorney can help you. So if you just have this information of the family information, if there's a will and if there's no will, information about who the beneficiaries are, and then an attorney in your area can go through this with you. If you tell them what the value is and what the debt is, then they can help you determine if there's an alternative to probate or if probate's the best way. Now, even though an affidavit is possible, let's say the property you're collecting is less than $100,000. Or if there's multiple beneficiaries, it may be a problem getting all of their signatures. If you can't get the cooperation of all of the beneficiaries, then it may be better to file a probate. Now in Arizona, there's two varieties of probate. The easier one is called an informal probate. What that means is that the court can grant the authority to the personal representative without a hearing. In order to do that, all the beneficiaries of the estate basically have to agree to appoint this person. So if everyone's in agreement, we can go the easy informal route. But let's say there's 5 beneficiaries and we can't get a hold of 2 or 3 of them. So what you could do is what's called a formal probate. That's where you give notice to all the beneficiaries. You say, hey, we're opening a probate. We're proposing that this person be appointed as a personal representative. And here is the date of the hearing. If you disagree, this is your time to show up and challenge. So that's how a formal probate works. A lot of times, no one shows up and the person is appointed, so they have the authority. Now, if someone does object and they do want to be the personal representative, then it's just good old litigation. It could go on basically forever. It seems like not forever, but it can take years if people are going back and forth and not letting anyone take charge of the estate. Hope you found this helpful. Download this checklist. Use it when you see a deceased person on title. And then reach out to an attorney in your area, in the area where the property is located, or where the deceased is located. and they can help you determine if a probate is necessary or there's some alternatives. Thanks everyone. If you're not subscribed, make sure you're subscribed to Maat Legal so you can stay tuned or stay updated when I go live and share little tips like this. Thanks.